Hello everybody and welcome back to Lysenko channel on YouTube. Lysenko is a federally registered trademark in the United States of America in Class 45 legal services. First of all, I would like to take this opportunity and wish everybody happy and healthy new year. Be kind, strong and relaxed. Have more fun, joy and love in your life. Focus on good and aim to success. Use Tai Chi method to redirect all negative energy against itself. Circle it in, reinforce it with your kindness and peace of mind, and then hit it back with good, positive, and healthy touch. Let it be the touch of 2022. So now the topic for today that I would like to discuss. I have just posted a new article on my website. Feel free to check it out, lysenkalo.com. My new article titled Reverse Trademark Confusion in Likelihood of Confusion Analysis. That's the topic. So, Lanham Act, or federal trademark law of the United States, protects trademark owners against infringement based on likelihood of confusion via false association, affiliation, or endorsement. So the concept of likelihood of confusion is at the core of the trademark law, and it is very important for both trademark litigation and trademark prosecution purposes. So trademark practitioners deal with likelihood of confusion analysis very often, or maybe even on a regular basis. So how it works? What's the most important aspects of likelihood of confusion? When we analyze this concept in courts, when we deal with trademark infringement, monetary damages, or equitable relief, in the Second Circuit, we use a so-called Polaroid factors test. Different circuits use slightly different tests, but the most important elements are the same. However, there's additional elements to it, and for the purposes of trademark prosecution, primarily before the U.S. Trademark Office, we usually use DuPont factors test. So the exact test may be slightly different depending on a particular circuit and whether or not we deal with litigation or trademark prosecution. But at the end, we analyze the same concept, the concept of likelihood of confusion. So as far as confusion, what it is and what kind of confusion exists, that's pretty much what my article is about, and primarily with focus of not ordinary type of confusion, but reverse trademark confusion. That's the title of my article. So ordinary or normal type of trademark confusion is when we have a senior trademark user. Let's say a business, it's established, it's been around for a number of years, and then we have a newcomer in the market afterwards. And that newcomer adopts the same mark or confusingly similar mark. And now that newcomer is benefiting of the goodwill established by the senior trademark owner. So this is a regular, ordinary trademark confusion, and this is type of confusion that usually happens. This is the type of confusion that trademark practitioners usually deal with. However, in addition to ordinary trademark confusion, we also have a different, related but different concept, and it's called reverse trademark confusion. So, what it is and how it works, and uh, reverse trademark confusion is possible primarily when we have a small business that's real, legitimate, but it is small or because of some circumstances not widely known or has its limitations in sales, promotions, advertisement, etc. But it exists on the market, and then we have a newcomer, but the newcomer is much larger business, much larger company with significant resources and capabilities. So this is where reverse trademark confusion sometimes happens. So because that because of the scope and amount of sales and promotions, that newcomer immediately occupies the market and basically uh, appears in the mind of consumers almost as the brand new uh, owner of a brand new product. And that's where a concept of reverse trademark confusion can kick in. And I specifically think that and this concept could be very helpful for small businesses, and it could help to protect small businesses' intellectual property rights if certain conditions are met. But uh, the concept of reverse trademark confusion is recognized by both the courts and the US Trademark Office. So in order to be able to assert reverse trademark confusion, one in federal court uh, and claim the protection of the federal law, one shall be able to demonstrate use in commerce, right? So basically, whether or not you have a trademark registration, uh, you still may benefit from the federal law if you can show use in commerce. However, having a federal registration is very helpful because it's prima facie evidence of your legitimate uh, trademark and your rights in it, right? So, but as long as a small business can satisfy that use and commerce requirement, it can benefit from possible reverse trademark confusion application in case that small business is encountered uh, in case that small business is challenged by a much larger company. And in a way, this is almost like application of a Tai Chi method. It's not really a legal analysis, but there's some similarity, right? In a Tai Chi, or at least part of the Tai Chi method, is that when dealing with your opponent, you not necessarily meet force with the direct force, right? You redirect it and you reapply it. So in a way, uh, reverse trademark confusion is kind of similar concept, right? You are much larger than I am, but this is exactly why you're gonna lose, because I'm gonna redirect that energy and I'm gonna use it against you. And basically, however, as long as I have the necessary basis, right? So in order to apply Tai Chi, I need to be able to understand how it works and know the ropes. So, however, as long as the small business can have use and commerce, clear evidence of use and commerce, preferably a federal trademark registration, it can benefit from the concept of reverse trademark confusion. So now this concept of reverse trademark confusion is recognized by both the courts, and my article has a nice and brief description of relevant Second Circuit court decisions. And it's also recognized by the United States Patent and Trademark Office. And just recently, we had a presidential decision on December 2021. That decision by the U.S. Trademark Trial and Appeal Board, also listed in my article, uh, and the Trademark Trial and Appeal Board specifically acknowledged the existence of this concept of reverse trademark confusion. They used it in likelihood of confusion analysis when reviewing the Polaroid factors, and they decided in favor of the senior user who was a small business. So it's an interesting concept, and I hope this article is interesting and also could be helpful, and specifically for small businesses. And uh, uh, I think it's also an interesting comparison with Tai Chi method. So try to take the most of it. My best wishes to you for the 2022 application of Tai Chi method in your life, dealing with any kind of negativity. Focus on something positive and good, and also remember this reverse trademark confusion. That's kind of also uh, kind of similar to application of Tai Chi, and maybe that would help you to deal with a possible trademark error in the future. Thank you very much. Happy New Year, and I look forward to see you with a new video soon. Bye.